everyone. Welcome to our fireside chat, Reparations, How to Fund Them and Avoid a Wall Street Takeover, hosted by Take on Wall Street, Americans for Financial Reform Education Fund, Service Employees International Union, and George Washington University Law School. My name is Ericka Taylor. I'm the Director of Popular Education for Take on Wall Street and the Acting Chief of Staff for Americans for Financial Reform Education Fund, and I will serve as your moderator today. So I'm going to lay out the case for reparations and the current landscape. Then we'll turn to Jeremy Bear-Friend, who will explain his reparations proposal, followed by Alvin Velazquez, who will share lessons learned from labor unions' pension fund experience. But first, let's start off with what we mean by reparations. Now, in this context, we're talking about efforts to repair the harm caused by slavery and its continuing legacy. Those reparations could be in the form of money, as it was for the Japanese American victims of internment camps, as well as in the form of land, scholarships, healthcare, housing subsidies, and more. Reparations efforts recognize that the U.S. became the wealthiest nation in the world as a direct consequence of using enslaved labor to dominate the textile industry. And we must acknowledge, by dispossessing Native Americans of 1.5 billion acres of land, which isn't part of the reparations struggle, but the land back movement. But focusing squarely on reparations now, consider that, and here I'm quoting Yes Magazine, at the outbreak of the Civil War, the market value of slaves in the U.S. exceeded that of banks, factories, and railroads combined, unquote. Representative Cori Bush's reparations resolution, which I'll elaborate on in a moment, estimates that enslaved Africans produced 222 million hours of forced labor for the United States from 1619 to 1865. That's the rough equivalent of $97 trillion worth of work. So as a consequence of that uncompensated forced labor and subsequent systemic racism, the 0.5% of national wealth held by Black people in 1865 had not risen above 2% by 2019, according to the Brookings Institution. That same year, the median wealth of white families stood at $188,200, while the median wealth of Black families was a mere $24,100. What's worse is this chasm has continued to grow. Between 1983 and 2016, adjusting for inflation, median white wealth increased by 33%, according to the Institute for Policy Studies. The median Black family, in contrast, saw their wealth decrease by more than half during that same period. Now, if that data doesn't make the need for reparations clear, consider this. The official end of slavery, except as punishment for a crime, was not the end of policies that kept Black people from accumulating wealth or ones that extracted the wealth they managed to gain. After the Civil War, thousands of Black men were rounded up as criminals so states could lease them to farmers and private businesses to perform unpaid manual labor. Their crimes were violations of Black codes, laws passed to maintain racial hierarchy. In rural Alabama, for example, changing employers without permission, false pretense, and quote unquote selling cotton after sunset were all arrestable offenses by 1890. This leasing of human beings, a form of slavery by another means, continued through the mid-20th century. It is not a stretch to think of today's incarcerated individuals as a contemporary extension of this history, since more than half of the 1.5 million people being held in federal prisons work for a few cents per hour, often for private corporations. And freed people who were able to avoid imprisonment were often consigned to a different type of wealth extraction, sharecropping, what Ta-Nehisi Coates has described as a system of debt peonage that was implemented by, quote, cotton kings who were once their landlords, their employers, and merchants, unquote, and who drove Black farmers deep into debt. By 1890, 75% of Black farmers were sharecroppers. By the early 20th century, U.S. laws hindered opportunities for Black people to create wealth on multiple fronts. Jim Crow laws allowed for legal discrimination against Black people, including restrictions on the kind of jobs they could hold and the incomes they could make. The newly established Social Security program didn't initially apply to agricultural and domestic workers, positions disproportionately held by Black people. So in 1935, 65% of all Black Americans and 70 to 80% of Black Southerners were ineligible to receive Social Security checks. State-sponsored redlining kept Black people ineligible for home loans, and racial covenants prevented Black people from moving into white neighborhoods. Today's Black home ownership rate of 43.4% is not only substantially lower than the white home ownership rate of 72.1%, but it's also lower than it was 10 years ago. And these are just a few of the policies and practices that build the case for reparations. 3 years ago, Take on Wall Street developed an interactive website, isoureconomyfair.org, which details such wealth extraction and exclusion from colonization to the present day. It reminds us of the vast scale of the problem and underscores that the solutions must also be expansive, thus reparations. In 1989, Representative John Conyers introduced H.R. 40, the Commission to Study and Develop Reparation Proposals for African Americans Act. It wasn't until April 2021, 32 years later, however, that the House Judiciary Committee finally voted to send the bill to the House floor for a vote, with 215 Congress members committing to vote in its favor. That vote, as you might imagine, never took place. Now, given that this bill has languished for decades, it's easy to imagine that it was a wildly ambitious effort to immediately disperse sizable checks to Black Americans. In fact, H.R. 40, as its title implies, has the very modest aim of establishing a federal commission to study the impact of slavery and recommend proposals for repairing its lingering harms. More recently, in May of last year, Congressmember Cori Bush introduced the Reparations Now resolution, which builds the case for why reparations are owed to Black Americans, lists various forms reparations could take, and pushes for the advancement of existing reparations bills like H.R. 40. It also identifies $14 trillion as the minimum amount required to bridge the Black-white racial wealth divide, which, as I mentioned earlier, is a direct product of economic systems designed to extract wealth from Black people and redirect it to the wealthy, almost uniformly white elite. Now, there has been an upside to the H.R. 40 slow progress, and that's that states and municipalities around the country have been moving forward with their own reparations efforts. The most advanced of these cases is in California, where state legislators introduced a package of 14 reparation bills in January of this year. These include a proposal to restore property taken by race-based applications of eminent domain, civil rights and education proposals, and more. Reparation studies or task forces are also in development in Colorado, Massachusetts, and New York. On the municipal level, Tallahassee, Oklahoma, one of the state's oldest Black towns, is fighting for reparations to revitalize the once booming community, which has been harmed by decades of banking discrimination, disinvestment, and the enduring legacies of slavery. Nearly a dozen mayors from Kansas City, Missouri to Asheville, North Carolina, and Providence, Rhode Island to Austin, Texas, came together a few years ago to form Mayors Organized for Reparations and Equity. They hope that their progress will help demonstrate to the federal government how reparations could be set up on a national level. Now, the $14 trillion price tag that Representative Bush referenced is one of many figures activists have calculated, but virtually all would require an investment of trillions of dollars. That's where Jeremy Barrafriend comes in. The question of how to fund reparations comes up again and again, and Professor Barrafriend is going to tell us about a paper he recently published that proposes a novel idea to address just that issue. His proposal includes using the quick capitalization of a massive reparations fund, one that, and I'm quoting the paper now, could successfully capitalize a multi-trillion reparations fund in less than a year, unquote. Now, this proposal raises questions about the governance of the fund and how the fund's capital would be invested. For that piece, we'll turn to Alvin Velazquez, who will talk about labor's experience with pension funds. He'll share how lessons from those fights could teach us about how to best set up a reparations fund so that its intended beneficiaries are in the driver's seat, not Wall Street. Now, here's a little bit about Jeremy. Professor Jeremy Barrafriend is an associate professor of law at George Washington University Law School, where he teaches federal income tax, tax-exempt organizations, and a seminar on redistribution and reparations. He joined GW Law after serving as a visiting assistant professor of tax law at NYU, where he taught federal estate and gift tax, tax procedure, and tax policy. Prior to academia, Professor Barrafriend was tax counsel to Senator Elizabeth Warren. Barrafriend's research has been cited by the U.S. Treasury Department and testimony before the Senate Finance Committee and by numerous think tanks and scholars. And with that, we'll turn to Professor Jeremy Berafriend.
Thank you so much. This is just such an honor to be here today. And Ericka, your introduction was just foundational to this discussion about reparations and how to pay for them. I'm so grateful for that introduction. Also to SEIU for joining us and your interest in this work. The presentation I'll be giving today is based on my forthcoming article in Howard Law Journal. And so I do want to thank Howard Law Journal as well for supporting my work and the student editors there who have been partnering with me on that. As a tax professor, I can talk about tax all day. So I try to limit myself with a little timer. I'll make sure based on this that I don't go over 15 minutes. So I think I can get this 50-page article down into these 15 minutes for you all. The big idea here is that taxes can be paid with something other than cash. So rather than paying a tax with cash, taxes could be paid with another kind of property like stock, equity in a company. And when we are willing to entertain this idea of taxes not being paid in cash, all of a sudden we have huge opportunities of more we can do in the public sector. So in my proposal, I recommend that we capitalize a multi-trillion-dollar reparations fund by requiring publicly traded firms that are listed on U.S. exchanges to remit a share of their firm to this fund. And I'll go into some of those details. But before getting there, just a reminder that the private sector relies on deals all the time that don't include cash. So in mergers and acquisitions, some of the biggest deals every year are non-cash deals. They are in tax called tax-free reorgs. And here a multi-billion-dollar company buys another multi-billion-dollar company by giving shares of the acquiring company to the owners of the target company. And that's the entire deal. Also in the private sector, we see companies choosing to compensate high-end executives primarily with equity rather than cash. And that's because both parties appreciate that there is a way to create value for both parties by using property other than cash. We have put an enormous and unnecessary ceiling on the capacity of the public sector by assuming taxes are paid in cash. And it is this discussion of reparations is just one example of what we would be able to achieve if we thought more broadly. So to give you a sense of scale here, if we were to tax the 500 largest companies in the US, which makes up about 85% of all income in that sector per year, if we were to have a 100% tax rate on those companies, which I wouldn't recommend, but even if we had a 100% tax rate on those companies, we would only raise about $700 billion. That would be the ceiling. And of course, within a year, companies would avoid making any money because they wouldn't get to keep it. Or that's what we would assume. But if we were to tax the market cap of all publicly traded firms, as I recommend in this proposal, we could get to $1 trillion with just a 2% tax. So 100% tax on corporate income, just in the hundreds of billions, 2% tax on market cap, all of a sudden we get to the trillions. So in my proposal, the first core component is that all publicly traded firms listed on US exchanges would be required to contribute shares into this reparations fund. The rate is debatable. You could set it. Obviously, Congress would have to negotiate that. But I hypothetically assume around 2%, and that gets us to over $1 trillion. The second core element of the proposal is that the shares that are issued into this fund or that are remitted, because some won't require new issuances, but of the shares that are contributed to the fund, they have to mirror the existing ratios of ownership that already are outstanding. So a company typically will have both preferred stock and common stock, and even within those classes, there'll be many classes of stock. And it's another part of this proposal that what's remitted to the fund mirrors those outstanding ownership interests. So for example, if a company had 100 shares already outstanding and 10 of them were preferred stock and 90 were common stock, then when they remitted their shares into the fund, they would have to reflect those ratios. So why is this such a good idea? Why am I so excited about it? And why was I invited to share this with you all today? The first component is really scale. As I've noted, the scale of the total market cap of these publicly traded firms is just an enormous tax base. And what that means is that we can achieve high value in what is collected with a very low rate. And there's a lot of appeal to having a low tax rate. In economics, generally lower rates are assumed to have less impact on the behavior of individuals and firms. So 100% rate, you would assume a very dramatic impact. 2% rate is going to have a smaller impact. Now, it doesn't mean no impact, but it helps moderate the impact. Another attractive component of this proposal is that low rates then also create political appeal. Many of you will be familiar with Senator Warren's discussion of a wealth tax and her account of just 2 cents on every dollar above the threshold. I believe it was 50 million. So here, again, we can take advantage of this enormous tax base by applying a low rate and thus having broader political appeal. By requiring contributions of equity into the fund, we would also be designing a progressive tax. That is, the individuals who are and households that are bearing the economic burden of the tax would also be those who are already most well off. And this is because the value that's going into the fund that's being contributed is principally from a dilution of the value of the other shares, right? If we assume that most of the companies that are subject to this tax just issue this new equity into the fund, then that is going to diminish the ownership interests of everyone who already had shares. The incidence of that dilution of value is going to be on for the U.S. shareholders, the wealthiest of U.S. shareholders. So for example, the top 1% of households in the U.S. hold over 50% of all stock in the U.S. So that's over 50% of the fund being funded really actually just by that 1%. The tax also ends up bringing in foreign shareholders because, of course, they would also experience this dilution, and they generally are not contributing to our tax base at all, but now would be pulled in. Another advantage of this proposal is that there are no liquidity issues. Companies that would be issuing this 2% of equity into the fund don't have to have any cash on hand. And that means we could also do it really fast. Issuing stock is routine. Publicly traded firms already have done it. They know how to do it. We have procedures for doing it. And we could achieve very large capitalizations in a very short amount of time. Lastly, I think an appealing component of this proposal is that I see it as somewhat self-enforcing, unlike other areas of tax policy. So with a corporate income tax, and I do support the corporate income tax, but one of the limitations is that generally both shareholders and managers conspire against the IRS to pay as little as in corporate tax as possible. Right? They have aligned interests typically to reduce payment of corporate income tax. With the reparations fund, because the shares held by the fund mirror all of the outstanding classes of stock that 98% of other shareholders have, you have aligned interests between other investors and the reparations fund. So games that a company might try to play to diminish the value of what is held by the reparations fund would also hit those other 98%. And so you would see some enforcement just by those investors to make sure that the fund had a stable value. So we've gone through the core elements of the proposal, why it's such a good idea, in my opinion. There are still many design choices, and this is where I try to put on my academic hat more than just being an advocate, and to recognize that here's the lay of the land of a lot of the decisions that ultimately will be up to the drafters, to the enactors for how the tax is defined. So when I worked in the Senate and a senator wanted to propose new tax, we would draw up a list of specifications and work with Joint Committee on Taxation on what those elements are. With this tax, one of the specification choices is, of course, the rate. So I described 2%, but it could be higher. I think an important consideration there is that the proposal is not to require the contribution of a controlling interest to the fund. So this proposal does not envision state-owned enterprises. 2% would not be a controlling interest in firms, and that is one of the appeals on that rate. But there should be a discussion about what rate is optimal. On timing, I also envision this being a one-time tax, again, to prevent ownership from eventually being remitted into the fund, or controlling ownership eventually being remitted into the fund. But timing isn't entirely resolved without also considering new firms that list after this initial tax. And would we want to have some way of still preserving new contributions by these newly created firms? Some additional design choices are how to deal with the incentive to be privately held, right? If we impose a tax only on these publicly traded firms, do we then push everyone out of those markets? And so you would likely want to have a companion tax that also addresses privately held companies to help even out those incentives. There's also a question of buybacks being used as one of the strategies for contributing to the fund. So I noted before that if a company were to issue into the fund, new shares into the fund, this would dilute the value of other shareholders. But it's also possible if companies had sufficient cash on hand to buy back shares, and so the issuance itself wouldn't actually dilute the ownership interests of anyone else if they were able to do so. Lastly, and I'm very excited to hear the questions from the audience and also from Alvin and Ericka on this piece. Of course, there is a matter of the governance of the fund and the payouts from the fund. I limited myself principally to the tax side, but of course, we would want to dig into how to manage a multi-trillion-dollar fund. So that is the core of my proposal of how to capitalize a multi-trillion reparations fund in less than a year, and we would do that by remitting equity into a fund, requiring remittance of equity rather than remittance of cash. And it gets to the core of what I think tax is about. Tax is fundamentally about how we share resources as a society. That is how we use the law to share our resources. And the question before us here is, are we going to share this resource or not? I'm excited to hear your questions and for the discussion with Alvin and Ericka. So thank you all for your time.
Wow. Thank you, Jeremy. It's a very exciting proposal. Really looking forward to digging into it. But next, we're going to move to Alvin. After which we'll go ahead and do the chatty part of our fireside chat. So, Alvin Velazquez serves as Associate General Counsel to the Service Employees International Union. His practice has focused on providing strategic legal counsel on advising the union on corporate governance, public finance matters, and on the impact of emerging technologies on workers. Alvin is a frequent speaker on these topics for the American Bar Association and for Spanish language media, and has testified before Congress. Alvin served as the chair of the official Unsecured Creditors Committee for the Title III bankruptcy proceedings of Puerto Rico. He has authored several articles and amicus briefs concerning the level of protection the law provides workers for engaging in online advocacy, as well as on bankruptcy and corporate law. He's also written law review articles on bankruptcy, which have been peer-reviewed, and corporate governance. His next article, Making Racial Equity Audits Effective, is forthcoming in the Chicago Kent Law Review. He is currently serving as the co-editor-in-chief of the forthcoming Bloomberg B&A Workplace Data Law and Litigation. And he also served as an adjunct professor of law at Georgetown University Law Center, where he co-taught employment law and taught a class on systemic racism, colonialism, and bankrupt governments. With that, we'll turn it over to Alvin.
Thanks so much for the great introduction, Ericka. I really appreciated coming to this event. And frankly, I was really excited about reading Jeremy's article here in the Howard Law Journal on paying for reparations. And I think part of the reason for that is, and if there's one takeaway for the audience to take from my comments, is how amazing the proposal is, but also how unremarkable it is to implement. And I know that sounds like a contradiction in terms, but let me explain here. So if you look at the history of labor unions and what they've done, labor unions fought for public pensions, right? And they fought for public pensions, they fought for worker pensions because they saw that as deferred compensation. They were viewing that as another way to ensure that as people got older, they would have the money needed from their working days to protect them. And what I think is what a pension fund has to do is they manage and hold equities, the kind of equities that Jeremy was talking about that would fit the bill for a reparations proposal. Public pension funds are used to, and pension funds generally, they're used to holding equities and stocks. They're used to dealing with when part of their portfolio changes because of a merger or having to sell back their stocks to a company due to a share buyback program. And so from a corporate governance perspective, what I found really interesting, or a pension fund perspective, is that some of the reasons why this kind of proposal might be doable from a corporate governance angle provides the justification for why this proposal is actually really doable and feasible from a perspective of governance. And I want to touch on a couple things. I think it's easy for people to say, well, public pension funds are kind of considered a controversial because of how well they're funded. But the reality is, most public pension funds took a major hit, and union funds too, after the 2008 financial crisis, which was broad and systemic. However, most of them have bounced back to be relatively well-funded. And I think that's something we have to keep in mind, is that at least traditionally the market has typically bounced back from shocks. And then what you raise a question about is distributions. Now, I don't want my comments to be taken to understand that the market always has it right and that pension funds have always worked exactly as they're designed to work. I think there's a couple of important lessons that we need to take away from how pension funds are governed to ensure that as this kind of fund that Jeremy can propose is implemented, it would do so in a sensible way. And the biggest thing has to do with fiduciary duty. To who does the fund owe money and its duties? Traditionally, the way ERISA and state pension fund law is set up is that the duty of the trustees, the duties of the representatives on a board of a pension fund are to the beneficiaries. Now, you might say, well, that makes sense. Duh, of course. Like whoever is defined as the beneficiaries, that's who the trustees should be there for. But what's happened in the case of especially public pension funds is that there's been a little bit of Wall Street capture and also a bit of what I would call a misapplication of the law. And actually, for those who are really interested in union history and specifically understanding this dynamic, I would point you to David Weber's book on labor's last best weapon, on share, because it has a great great chapter on just how concepts of what are called fiduciary duties are used to hurt workers. And let me tease that out for you. So you could imagine, under traditional concepts of fiduciary duty, a trustee is there to ensure that the fund is managed and that money is available to pay out the beneficiaries. In the case of this fund, the descendants of enslaved people. However, what happens then is that there's times where the funds have to make decisions that actually hurt the same people they're supposed to be helping. In the labor example, what you'll see is, for example, private equity firms coming to pension funds with an investment allocation that would essentially wipe out the jobs of the people that were the beneficiaries of the fund. And what's weird is that the way that the law has developed and the way that most people think about it, they'll say, well, that's not a breach of fiduciary duty. This deal is good when we think about the beneficiaries as beneficiaries of a fund. And you're like, well, yeah, but you're literally putting them out of work. So shouldn't there be some considerations for the health and welfare of a plan sponsor? And as of right now, that's something that's hotly debated, but it is a huge issue in the management of a pension fund. And I think if we're going to set up an equity fund here to deal with reparations, that's got to be something that's cooked into the design of the fund. So in that way, for example, let me use an extreme example. Let's say there's a company that just in principle refuses to hire Black people. Now, of course, we know that's also against the law, but under current thinking regarding fiduciary duty, this fund would still have to invest and be part of that of the governance of that firm and be a shareholder and just continue on as if nothing happened, even though that firm was literally in the business of not hiring descendants of enslaved people. And that's some of the illogic that would have to be fixed. And that's a lesson that I think labor has learned, and also other advocates. Now, the other thing I want to touch on is when it comes to fiduciary duty and governance is not only do you have to think about where do the duties lie and to whom, but also who's advising the people who handle the money. And here's what I mean. A lot of times what you see in pension funds and public pension funds is a sort of path dependency. And that path dependency, right, on its surface also makes sense. It's, well, the trustees of all of this money should be advised by the best and the brightest. And they should be able to, rely on the advice of competent lawyers and competent financial managers. And that's all well and good. However, a lot of times the training and orientation of these managers is steeped in this kind of older concept of fiduciary duty. And what happens is that the trustees learn, well, fiduciary duty, I have to meet my fiduciary duty, and I personally do not want to be held liable, which is the penalty right now that's out there for most public pension fund trustees. And they'll say, well, if I rely on the advice of my advisors, I won't get in trouble. Therefore, I will have no trouble come to me. Therefore, I will follow the advice that the advisors give. And sometimes because of the revolving door effect, some of that advice is a little bit biased or doesn't take into consideration some of the, there's a little bit of a blind spot to some of the social justice norms that we're talking about here today. And so in that regard, a proposal to make sense of that would be to change how the trustees can be held liable, or to what extent, so that there's a more limited liability, so that they have greater discretion to pursue the goals of the fund, of this reparation fund. The third thing I want to touch on is setting up governance. In terms of setting up governance is setting up the elections. You've heard me talk about trustees. At certain pension funds, different states do it differently. Some states will have pension fund trustees directly elected from the membership or from the beneficiary class. Some of them will have classified boards of trustees, meaning that there's 7 seats, 1 goes to the governor's appointee, 2 go to people who work in local schools. For example, if you're using like an education fund, 2 who are teachers. There's a set of divisions. Here, I think if you're going to set up a fund, you have to be in any statute that Congress drafts. You have to talk about how does somebody get on the board of trustees. An election here would make sense that's limited to participation to the descendants of enslaved people. In this case, a kind of election that's limited to those who would benefit from it. On top of that, the other thing, as far as the elections would be concerned, is, like I said earlier, the idea of a limited liability, or kind of a tailored liability for trustees, so that they have the ability to use some discretion when appropriate on some of the funds ends. And then on the third thing that I wanted to touch on is when it came to voting and using shares. So I thought that when I read Jeremy's proposal about 2%, I thought that that was an interesting number. The reason that that's an interesting number is because it's just enough of a market cap of the company to have a voice and have enough to be paid attention to. However, a lot of SEC trigger points occur when you have 5%, as far as voting proxies and as far as engaging in the governance of a firm. So this proposal sets up this fund to be a powerful advocate in the decisions of corporate America without having a controlling influence. There will definitely need to be some guidelines about how this fund uses those shares. And what I actually really liked about, one thing I liked about this proposal, is that Jeremy outlines how any issuance of new stock should be in direct proportion to the stock that's out there. So if 10% of the stock is a special dividend stock, then that's what this fund should receive. That's a really interesting proposal, because it means that both on the pension fund side and the corporate side, it doesn't disrupt common practice already. So that's my comments. I'll stop there. I have plenty of other thoughts, but I cede back the rest of my time.
Thank you so much, Alvin. It's really invaluable to have your expertise and to hear from you about how to get this plan up and running based on the plans that already are out there, that already are up and running, and some of the dilemmas that they face. You noted a few points that I'd love to draw on before we open it up to more questions, and I believe we have a few minutes for that. One piece that was so helpful, and I'm glad you emphasized this question on elections and the necessity of having some election procedure, and to just say that in another way, which I think we're on the same page here, is a part of the goal is about self-determination, that it's essential that the community impacted by slavery and by the compounded harms of racism after slavery is the community that gets to decide on how this fund is run and where the fund money goes. So I think that is a key value and a question to ask with every other subsequent decision of, does this contribute to self-determination? Does this contribute to that goal? Rather than, is the entity that was responsible for slavery, right? I see the federal government as having a direct role in preserving and maintaining slavery. Should the federal government be the one that's actually controlling the fund? And I think in the end, for the self-determination principles, ultimately that power needs to be given away. The other piece that you noted that was so interesting is this 2 versus 5% choice. And 5 seems also like a very helpful potential threshold to consider. And I like you bringing that in, and your recognition also of the alignment of interests of the fund with what companies are already thinking about and dealing with other shareholders and other investors. Right? They are managing a lot of this. One piece that hasn't come up yet that I also wanted to draw out is on sovereign wealth funds, another example where we have democratic capitalist economies where there's nevertheless some public ownership of enterprise. And in Norway, for example, there is a sovereign wealth fund that has $1.5 trillion. 1.5 billion. It's smaller, 1.5 billion. But that fund is used also as for retirement beneficiaries, I believe, but for a public purpose, and it isn't seen as somehow competing with private sector investment. It is alongside.
Yeah, let me respond to that, to the sovereign wealth fund part,
Mhm.
because I actually, as I was reading through your paper, I must have put about 10 check marks where I said, this is exactly what public pension funds are like, right? And so I think in that way, right, you were noting how sovereign wealth funds have the ability to kind of, affect things, right, and kind of act as an extension of the country, but without impeding on the markets. I view public pension funds the same way. I haven't actually heard anyone in the United States credibly say, for example, that public pension funds are socialistic or something like that. Like, I know you talk a little bit about that in the earlier part of your paper. Like, no one seriously states that. They see it as an independent entity, right? That, yes, has some control from the government due to like political interference, but manages their day-to-day with relatively little interference, right, in terms of what they do. And I think I see this fund the same way. I really appreciate your self-determination point. I think that's a very real point. But I also take to think that the proposal you had, or what was so interesting about it, is that it kept the private market paradigm. So for those people who are concerned that such a thing is some kind of whose boogeyman, let's say, is socialism, right? That this actually appeals because it looks a lot like the kind of things that they're used to already. And I think that's the part that really that's one of the factors that really just kept jumping out at me over and over as I read your paper.
Thank you so much.
You're welcome. Thank you.
Well, thank you both. Really fascinating proposal. Great texture that you've added, Alvin, around sort of how this could be managed. And we want to move on to questions from the audience, but I'm going to start off with with a non-technical question for both of you. How did each of you become interested in reparations in this work?
I can take it first stab, Alvin. Does that?
Yeah, go ahead.
Yeah. So I've always been curious, but not very well informed about reparations. And the turning point for me was in my seminar on tax policy. I had taught that for years at NYU. I've now taught it for years at GW. And the course is centrally about redistribution. It's about distributive justice and who has what and how does the state organize that. And it was in that context that I realized, the kinds of thinking that are happening in reparations and considerations of corrective justice are also incredibly useful for making tax policy choices or in conversation with distributive justice. So it was my work in tax that ended up connecting me to reparations.
Yeah, and I was going to say, for me, I was teaching about a couple articles on reparation in my class on systemic racism, colonialism, and bankrupt governments, and a lot of the and I think as I thought through it, I realized, for example, I struggled with this concept about whether cities were the right entities to do this, and so I always struggled with the ability to implement a feasible proposal, right, for reparations. And I thought that, to borrow a little bit of tax lingo, I thought doing it at a city level or county level meant that the tax base wasn't wide enough to distribute the costs needed to do that. Especially because some of the, for example, my class I taught on Detroit, I said, okay, well, let's think this through. Detroit is a city that's 80% Black, and you're asking them to do a reparations fund through a sales tax. That seems to undermine, right, the goal of the fund, especially because, as Jeremy knows, sales tax are typically seen as very regressive taxes. So that's how I've struggled with it. I'm kind of a person of belief who's seeking understanding, to paraphrase an old church phrase.
Excellent. Thank you. Thank you both for that. And I'm going to go through some other questions, but want to encourage and invite the audience to raise your own, to share them in the chat, and we'll get to as many as we can. So my next question is really for both of you. And I'll start off with Jeremy. Would companies avoid paying the reparations tax? We know that corporate tax. There are lots of corporate tax scofflaws right now. So how would that work?
Right. So absolutely, in designing any effective tax, you have to anticipate that there's going to be avoidance, and there's clearly a strong incentive to try to avoid. One helpful tool there is that we actually have an accumulated body of law on anti-abuse rules that I think could still apply. So something like the economic substance doctrine or substance over form rules, those could apply to some of the games that haven't even been invented yet, but that might come along the way. It's true that we are seeing companies still get away with paying, I think, lower effective rates than the law allows through their avoidance techniques. But some of that is actually more attributable to having an IRS that hasn't been funded for over a decade or has been seriously underfunded. So we've been in a period of almost non-enforcement at the high end. And so I think that also gives me a bit more hope. But I think one of the biggest avoidance techniques that I'd be concerned with is simply becoming private. So it would be important that there be some type of parallel tax that would apply to privately held firms of a certain size, above a certain amount, because smaller firms aren't going to be publicly traded either. So we're still talking about the big fish. But so the really large firms, and one of the proposals that's out there for addressing that comes from Brian Galley, David Gamage. It's called an ultra proposal. They have an idea of creating notional interests in firms, but I would like that to also be a parallel.
Excellent, thanks. And Alvin, I'm not sure I know it's a little bit outside of your wheelhouse there. Do you have anything to add on that one?
No, the only thing I would add is just that when companies go public, there's a number of changes that happen, right, that impose costs that they previously had not had. And so I think that one of I see the proposal is adding a different sort of cost that'll probably just be bared in the public offerings anyways, especially for new companies seeking to go to market.
Excellent, thank you. All right, we're going to go to an audience question, a question from the audience now, which this might be to either of you. I think both of you could address it. In your view, what does the process look like in getting the equity fund created and funded?
Well, I think it could be done really fast. I think companies issue shares all the time. I think the companies already keep track of all the shares that are already outstanding in the classes that exist of each in all the proportions. So doing a new issuance has some overhead costs. You hire attorneys to advise you, make sure you meet all the regulatory requirements. But I think a few quarters of the year, a few financial quarters would be enough to have this up and running by 2025. If we pass it, I think it could happen within a year. The question of who is eligible as a beneficiary, that is itself a huge question, and I don't see that really as my own personal expertise. It's in the end, I'm here to point out where the money is. I'll say, since this hasn't come up yet, I do want to flag that taxes aren't the only way that we can achieve reparations. There are many ways to pay for reparations, and I wouldn't want this to hold back some of those other pursuits. So, for example, we could just use debt. We borrow to pay for a lot of government spending. We could borrow to pay for reparations as well. That's a possibility. In the land back context, right, you also have returning federal land to indigenous people, and we could see use of federal assets or federal land, perhaps in a reparations context, also for formerly enslaved or descendants of the formerly enslaved. So those are two of some additional ways to fund it.
Thanks.
And actually, I wanted to touch on one part of this, which is the question was, are people in the U.S. territories and colonies entitled to them? And for SEIU, this is a big deal in the sense that SEIU has frequently called on the decolonization of the territories, including in Puerto Rico, where we have a substantial amount of members, and obviously I've worked on a lot of that. I think that one of the same kind of principles would apply. The way I thought about this, and this is just a thought bubble, is one way you could do this, and that you get this in, for example, the mass tort context, right? Meaning, in the mass tort context, people get harmed by a product, let's say, and they get different harms from that product. One set of people might have a lifelong disease, and others might have an acute disease that immediately kills them, and others might have something that it harms them but doesn't necessarily take out their quality of life. What you see in the mass tort context is the creation of a fund and an administration in which you go in and say, this is how I've been harmed. I think in the reparations context, given that the process attacks issues of what I would call generational wealth, and the way you set it up, Ericka, at the beginning was about generational wealth. You could imagine, for example, looking and trying to figure out how many generations do you trace back of that harm, and using that as a metric, for example, for administering initial applications to that fund. That could be one thing. Another metric could be the amount of descendants that you came from that were also harmed by, say, slavery, as a potential way of administering that. But that administration question or design question comes up pretty often in the mass tort context, and is something that gets hammered out in settlement. And I know we're not talking about litigation, but I am trying to say that there are some analogs to draw from there in the design of a statute here.
All right, thank you both. And sort of, Alvin, sort of a related follow-up question. So once we have this fund established, let's talk about the governance. How would the reparations fund spend its money? What would that look like?
Well, I think that there's a couple of ways, right? So you have two sorts of payments there. The first, of course, is the payment of benefits, which is the primary part of the fund. But there's also an overhead as well that goes into that. And of course, there is you would need staffing, you would need people to help administer this fund. That part is, I think, is unremarkable in that way. However, there is a real question about how to handle overhead expenses. I think, one, yes, you get lawyers, you get financial advisors, but there is a real question of who and how much do you pay for them and for those services, and where do you get them from? What training do they have? Now, on the payment benefit side, I kind of go back to the mass tort context. It's designed, and you would have to do it as a pro rata share of however much money those the equities pull in. I think something that Jeremy noted in his paper that I thought was right on is, unfortunately, for better or worse, it's tied to market, right? And so in that way, this reparation fund succeeds when the market succeeds. And as we know, the market is a volatile and fickle. I would argue we're still feeling the effects of the 2008 market calamity by way of example, but we also are feeling COVID and the effects of the disruption that caused there. So I think there could be a possibility that in certain years, right, if the market's very, very lean and no one's paying out dividends, that it's going to be a lean year from that fund. And then when years are flush, boom years, that there's going to be a higher amount of reparations that get paid out of such a fund.
Got it. Thank you. So a question from the audience for Jeremy. What are the barriers in getting the reparations fund from concept to reality, right? And what are your thoughts on how to overcome those barriers? For example, opposers might point to the dilution of the individual stock price and impact on cost of capital. So what are your thoughts about overcoming those arguments?
Yeah, I mean, the reality is that reparations have never been paid to formerly enslaved people or their descendants. This is anomalous relative to many other victimized communities that have received some form of reparations. The only reparations for slavery that are in the historical record are actually to slave holders, people who owned enslaved people, who were paid by the federal government for the value that was lost due to emancipation. So given that history that we know it hasn't happened yet, it's true. It makes it seem like a really tough thing to win. And yet it is so necessary at this point. Now I see no alternative. It has to happen. And I think that, and the time is now. There will be opposition. One of the areas also I would expect to see would be litigation, right? When President Biden forgave student loans, people were unhappy with that, went after with a lawsuit in the Supreme Court, ended up siding against the administration. So here too, there could be a question of, well, is this going to be lawful? I think the best defense there is to view it as an excise tax. There's actually broad congressional power to have excise taxes. The federal government has done that before on banknotes, on issuances of bonds, and we could do that for the issuance of stock on U.S. exchanges. But I would also recommend looking to the paper. It is publicly available on Social Science Research Network. It's 50 pages. It has a few hundred footnotes, so it's not everyone's favorite activity, but you're all welcome to look there. And I'm also have the good fortune of having a forthcoming report with the Roosevelt Institute that will be a follow-up on the paper for a broader public audience. So I also hope to get into those questions in the report.
Yeah, actually, can I ask one quick question, Jeremy, just for this audience? Wasn't the ACA basically the Affordable Care Act won on a tax argument? And isn't that just like another example of how
I think the taxing power is broad. It's clearly in the Constitution. In multiple places, Congress has the power to tax, and a tax is not a takings. So if something is viewed as a tax and accurately understood as a tax, then the federal government is entitled to that policy as long as it is in service to the general welfare. And so you would want to make an argument that the reparations are for the general welfare, and that is consistent with Congress. So, for example, in giving funds to the victims of 9/11, not all of us were victims of 9/11. Only some of us were, but the federal government spent money to repair that group, and that was out of general funds. That wasn't only those who were responsible for 9/11 paying for the victims of 9/11. That was all of us as members of this community contributing to those victims.
Thanks. Well, we're getting really close to the end of time. I'm going to ask a final question from the audience because I love it. Because it's an organizing oriented question. But if y'all could give maybe 15, 20-second responses. So the question is, don't know if this is relevant yet, but how can this possibility be taught to the general public? And when should this start? And when should this teaching start? And how can individual reparationists help with the process? The second part is, will the recording be available to attendees in the future? Yes, and we'll get to that in a second. But what are your quick high-level thoughts?
Well, I'm an educator. I love to teach, so I spend my time trying to share this with my students, share it with the public. I think the more we can talk about the need for reparations, the better. So that's one of my priorities. Education is a core part of organizing. It's not the only way to build power, but it's an important component.
Yeah, I would say first, for those who are scared about the 50-page paper, read the introduction. It really flows and it's really quick. And I thought you did a great job, Jeremy, of like tying it all together. In terms of kind of more broadly, right? This is the kind of thing where organizations or organizers that are part of membership organizations can share this kind of information more broadly, right? And start thinking of it in terms of election constituencies, especially if you think about governance as elections and trustee elections. Well, not just unions, but all sorts of groups in the DC area know how to run elections, how to organize elections, how to get people on the ballot, how to construct the schema that even gets them in the ballot in the first place. So I think there's tools there, and they just have to be activated.
Thank you so much, both Alvin and Jeremy. I knew if we weren't in a webinar format, we'd hear the audience applauding wildly. Thank you all, audience members, for participating. Please continue to follow Take on Wall Street and Americans for Financial Reform. Everyone, you can go to youtube.com/SEIU at Take on Wall ST to rewatch this video and anything you've missed. Be sure to check out isoureconomyfair.org to dig into a little bit of the history of our financial system and who benefits and who loses. And thanks for your attention and for coming. Again, thank you so much for this wonderful presentation. And we look forward to seeing it, hopefully being put into action. All right, take care.
Thanks for having us on.
Thank you.